Hello people, it is I again. A little video for you. This is in relation to what side of the court you're in, and in relation to who is opening up the court. Now the person who creates the court becomes the prosecutor. You become the person making a claim. And in the Western culture, the Commonwealth lands, that is, the Western cultures, the burden of proof is on the prosecutor. Yeah, if you say something's true, you have to prove it's true. If I say you're a thief, it's not up for you to defend that you're not a thief. It's up to me to prove that you are a thief. I have to have witnesses. I have to have a video recording. I have to have the thing that was stolen, receipt for it, proof that you took it, all kinds of stuff. I have to prove that you are the wrongdoer. Now, something I was looking at recently is in relation to Rolf Harris, actually. He was in the news a lot recently about all kinds of sexual weirdness, whatever. And something I realised on here when I was just reading through this as a point of reference. One of his convictions was deemed unsafe, whatever that means. But I noticed here, I always like the form. Every bit of form and writing on a claim, especially when it's done by these legal professionals. They know what they're doing. They don't make mistakes. Well, they might make mistakes, but they correct it pretty quickly. But I was interested in here. It had the respondent as Regina and Rolf Harris, and Rolf Harris was underneath, but the applicant was Rolf Harris. So it was his court shortly, and Regina was on top. Now I'm not sure as to the nuance of why that's been done, but you know, if I show you some other appeals, the claimants are appellant, the appellant, you know, even here the Queen was the appellant here, and the campaign against, this is some other case against selling arms to Saudi Arabia and other countries that aren't particularly up there with human rights. So they're on top, and then you've got the defendant underneath it. So this is the Queen against the Secretary of State. It's quite interesting, that. I might cover that in another video. Mr. Justice J, so we've got here BuzzFeed Inc. against someone or other. So here's the appellant, and again we've got the respondents, and there's two respondents there. So the appellant is on the top line. Again, PW, whatever that is, and these are all the wrongdoers. And again you've got Camilla, appellant, and Gerald as a respondent. And I was like, well, why on earth? I mean, it's not the Queen, it's Regina. So who is this Regina? Which is awfully interesting. And if the implication here is that this is the Queen herself, is it because she's the... Well, Regina isn't the Queen. It'd be Elizabeth Windsor, wouldn't it? Or it'd be the Queen, like it was in this. Unless the Queen, or is that a different Queen, or how's the Queen differ to Regina? So something's going on here, and it's very curious. It got me thinking about what Carl Lentz said about what the IRS do in America when you go to tax court, is that if you wish to like question something about your tax bill with the IRS, they invite you to create a court where you bring the IRS in as the defendant, and you are the prosecutor. And what you're actually doing is you're trying to prosecute the IRS to say that you're trying to convince the IRS that you don't owe that amount of tax. So the burden of proof is you are now in the burden of proof to show that you don't owe that amount of tax. It's kind of a really clever and sneaky. It's sneaky, but it's just using knowledge over your ignorance. That, you know, if they know if they're the defendant and they bring you in to prosecute against them, they just have to sit there and shut up. They don't have to prove anything against how much tax you owe, because obviously they don't know. But if they can get you to open up a court to then bring you in, and now you are the prosecutor, you are the claimant, you are the guy who has to prove that the IRS does or doesn't require this much tax from you. It's kind of weird, because it's such a funny kind of reversal of roles, where you think you're defending yourself, or if you're defending, you could quite easily kind of naturally comes when the IRS is involved. You think the IRS are coming after you, but when you go into the IRS tax court, you're going after the IRS, so the IRS can sit there and watch you fail. Because you don't realise what side of the court you're on. And I found the audio clip that Carl would actually mention this in.
Taught me everything. She said, you're the one who petitioned in tax court. You're the burden of proof now is on you. that the IRS doesn't have the capacity to tax you. You're not the defendant. You're the prosecutor. You petitioned the court. It's like watch any old movie, watch any old Bible movie, King David kind of thing. There's people petitioners outside of his castle waiting to have their case heard. They're the petitioners. So the IRS tells you, so if you want to challenge our assessment on you, file your petition with tax court at this address within 30 days, or we're going to start doing some really bad things to you. So what you should have done is just keep sending letters back and forth to them and say, wait a second, do you have the right to claim that I owe you a debt? Who has that right? I thought you were the IRS. I thought you were a state agency. I thought you had privileges, duties, and obligations. Where do you have a right? Do you have a right? Can you show me where you have that right to make a claim against my person or my property? And they don't. They have no rights. No man's going to come forth, like I said to my mom.
And that's basically the gist of it. So, I mean, getting you to come to court, the IRS now shifts the burden of proof onto you, and you have to prove to the IRS that you don't owe that tax. But they're going to obviously show all the legislation and stuff that says that you do. So you're kind of tricking yourself. You're bringing them into your court, and you're trying to disprove something that is obviously enforceable, or at least what's the word? They can show through legislation and all the other stuff that it is due. And also bear in mind, you tend to fill in something called a self-assessment. Yeah. It's time for your self-assessment, everybody. Self-assessment, because we can't assess you. You have to assess yourself. You have to testify against yourself, essentially. That's what they're asking you to testify against yourself, so that we know how much tax you're due to pay. And that's it. That's essentially it. So in this case, with Regina being on top, whose court? Who actually created that court? Did Regina create this court and wanted to come in as a defendant to bring in Rolf Harris as the prosecutor? Or did Rolf Harris create this court in order to have Regina come in, but then as a defendant? This seems to be done very deliberately. If I go down just to the bottom here about the overall conclusion, so the conviction on count 1 is quashed as unsafe. So quashed, I think, let's find out exactly what quashed means. Quash. To make void. Okay, so why don't they just fucking say void? It really does annoy me. Probably because they don't want people to know the words. I don't know, quashed as unsafe. Unsafe again. Leave to appeal and extension of time has been granted. Leave to appeal is refused on counts 2 to 12. So the other 2 to 12 counts are remaining. And we have considered the question of a retrial on count 1, but the Crown does not seek a retrial. So the people who prosecute doesn't seek to retrial it. We agree that 1 is not in the public interest and make no ordinance in that respect. So they essentially say, yeah, whatever, you can get rid of that one. And if you also look here, in brackets here, it says, neither of the above named counsel appeared in the court below. In the court below. Which is their court. So the court was the appellant. So why isn't the appellant on the top? It's quite, I don't know, I just don't get the how they've laid this out. It's very curious to me. I'm sure there's a reason. So the appellants, so it is the appellant's court, but the respondent's on the top line, and no one representing the defendant in that case showed, because the defendant doesn't need to show. Only the prosecutor has to show to testify to the truth of his accusation, you see, or his claim, let's just say, keep it simple. But I just thought that's quite interesting, that why in this particular case the respondent is on the top line in the appellant's court, when on all these other cases the appellant is on the top line. Curious, fascinating. That's what happens when you try to interpret legal paperwork. But yeah, just be aware when you're in court, ask, whose court is this? Who made this court? Am I the prosecutor here or am I the defendant? Who's prosecuting this claim? What side of the court am I? Am I on the legal side of the court or am I on the common law side of the court? These are the kind of things you need to get straight in your head when you're in court, so that you know exactly what game you have to play. whether you can sit down, shut up, and don't say anything, or you have to stand up and act and prosecute your belief, your claim.